So now moving on to family. Anu and Sabha have been partners for 40 years. They have a minor child together, which Anu had legally adopted. Anu recently passed away after a prolonged illness. Sabha was not able to be with her during her last days since her family refused her access to Anu in the hospital. After her death now, Anu's family is threatening to take away the child and the house since it was Anu's and she died without leaving a will, in which Sabha shared her life with Anu. So how does the law play out in this context, right? Now, same-sex or same-gender relationships are not recognized in India, which just doesn't affect marriage. It affects a bunch of other legal rights and obligations. Now, for instance, an area of concern which we've recently realized is surrogate decision-making. For instance, often in hospitals, the person who can take a decision for you is often your spouse or your family member. And even though that person, you may not be in the best of terms with your family or your natal family, but they are the ones who are recognized as your family. And you might have a partner for 40 years, but she may still be denied access to you in the hospital because you can't prove that relationship. And even right now, in terms of legal frameworks, we don't have a legal framework for surrogate decision making.
Yeah, exactly. So there's actually no real
law.
certainty about who gets to take decisions about any kind of person towards the end of life or generally for healthcare decisions.
Yeah.
So I might be a cisgender old man who's estranged from his wife and who's estranged from his son and widowed, and I might still have to have my son come and take decisions for me about when to plug me off, when to unplug the ventilator. So the law is not satisfactory even in the case of heterosexual relationships.
Yeah.
Obviously, it has, again, even more disproportionate impact on relationships that are not recognized in the eyes of the law.
And it's not just marriage, right? Because it's about adoption. Because since only one person adopted the child, the other person doesn't legally have a right to the child. Similarly, property. How do you deal with questions of succession? Does the same-sex partner get any share in the property? And all of these legal frameworks right now, because often marriage becomes the entry point into these other laws, because marriage is so central to Indian family law that adoption, guardianship, succession, they often revolve around marriage. And therefore, how do you deal with a family law regime that keeps marriage at the center of it? Because since the law doesn't recognize these relationships, it often doesn't recognize these other aspects that come from marriage, as Dhwani pointed out. But often, like in our consultation also, it was suggested how we also need to develop critiques of these frameworks. Because often in popular discourse, we focus a lot on marriage because it seems as the next big step to take. But we often forget that often these frameworks are highly patriarchal and promote stereotypes and unhealthy gender roles. And queer relationships are themselves transgressive, and should they be part of such an existing family law which is not gender just, which doesn't even is not equal in that sense. And often in the West, there have been debates about assimilationist strategies and radical strategies about whether should just fit people into existing frameworks, or should we rethink of these frameworks? And one of the important points which we realized was for the law to respond to the realities of the community.
Exactly.
How do we keep aspects like caregiving, how do we keep other forms of relationships at the center of family law, rather than just focusing on the romantic, monogamous unit? How do we think about alternative families? How do we think about families of choice? And how do we ensure that family law frameworks actually respond to these realities, rather than working in some patriarchal conception of the family which doesn't work for everybody?
Yeah, and I think another point that came out during our consultations in Delhi, at least, was that apart from this and apart from questioning the structure of recognized relationships themselves, there might still be ways in which to queer the law by using existing provisions creatively. So people talked about surrogacy, for example, as a way in which same-sex relationships could create the families of choice that they wanted.
Yeah, but with the surrogacy regulation bill, that becomes a problem.
Exactly, yeah.
And how do we recognize relationships of caregiving? How do we recognize relationships that are not romantic or sexual? People might be living together, they might just be codependent or might look after each other and might want to have some rights and obligations as part of that unit. But how does family law even account for such things?
Yeah.
So we need to more critically question existing frameworks before we think of what
and some innovative kinds of relationships like this are recognized in other countries.
Yeah, so for instance, Tasmania has a relationship act where you can just register a domestic relationship. It doesn't have to be a romantic relationship. Similarly, France has its own law on civil
So it could be two
That's-
friends
yeah.
living together
Yeah.
and deciding to create a mutual set of rights and obligations between themselves, where you are valuing that kind of emotional and economic dependency as opposed to a very specific kind of sexual pleasure that seems to form the basis of marriage in our current legal framework.
So in our Delhi consultation, a lot of people emphasize the need to recognize the values we want to preserve in family law as the community. What are the values we want to focus on? Do we want to focus on sexual pleasure or caregiving or economic dependency? What are the values that are close to us as a community which could then be the building blocks of a potential law? For the